Good evening, everyone, and welcome to this evening's panel discussion on the topic of FinTech, regulatory trends and lessons for the future. My name is Andrew Godwin, and I'm a co-director of the Corporate Law and Financial Regulation program at the Melbourne Centre for Commercial Law, which is the host of today's webinar. Let me commence by acknowledging the traditional owners of the land on which all of us are located, at least in Australia. For me, in Melbourne, it's the Wurundjeri peoples of the Kulin Nations. I'd like to pay my respects to their elders, past and present, and also welcome any Indigenous people who have joined this evening's webinar. Before I introduce our distinguished panelists, I'd like to say a few brief words about today's topic. Financial technology, or FinTech, is one of those growth areas that seized our imagination and attention for well over a decade now. All of us who work in the area of financial regulation or financial services law have had to engage with it in one way or another on a diverse range of issues. These issues include the challenges that FinTech has created for regulation, the nature and regulation of new asset classes such as cryptocurrencies, new ways of raising finance such as DeFi or decentralized finance, and innovative ways of delivering existing financial services through new technologies. FinTech is a huge area of innovation, and I might say a huge area of disruption. And it spawned its own lexicon with new words and concepts and what one might refer to as offshoots or derivatives, such as RegTech, the use of technology for regulatory purposes, SupTech, the use of technology for supervisory purposes, and also TechFin. TechFin refers to technology companies that provide financial services, often in reliance on the competitive edge that they have gained in the area of data and the use of big data. So technological innovation in this area has been so fast that law and regulation have had to work hard to keep up. Indeed, I'd suggest that innovation has been so fast that FinTech itself, as a general concept, has had to work hard to retain its currency in the face of specific challenges such as artificial intelligence and big data. Another point to note, I think, is that the impact of technology in the financial sector has become so pervasive that regulation is beginning to focus not just on how to balance traditional elements such as innovation and consumer protection, but also on how to address and achieve financial stability and sustainability goals. We're very fortunate this evening to have two panelists whose expertise in these areas is unrivaled. Those with even a basic knowledge of FinTech will be aware of the research of Professor Douglas Arner of Hong Kong University, along with his co-authors, Professor Ross Buckley of the University of New South Wales and Professor Dirk Zetsch of the University of Luxembourg. Douglas's name is synonymous with seminal research on FinTech, and together with his co-authors and collaborators, he is, I think, the most widely regulatory scholar in this area. Professor Buckley was going to join today's webinar, but unfortunately has had to pull out at the last minute owing to personal commitments. As I said, Douglas and his collaborators have published extensively in this area. Cambridge University Press recently published a new book by the three of them called FinTech, Finance, Technology and Regulation. Our second panelist, Commissioner Kate O'Rourke, was appointed ASIC Commissioner in August 2023. Prior to that, she was First Assistant Secretary of the Consumer Data and Digital Division at the Commonwealth Treasury. Kate is therefore eminently qualified to talk in particular about the impact of FinTech on digital transformation and what that means for financial services regulation and for financial services regulators such as ASIC. In terms of the format for this evening's webinar, I'll be inviting each of our panelists to speak for about 15 minutes. I'll start with a question to Douglas and then follow up with a question to Kate and then come back to Douglas before leaving hopefully about 15 or so minutes to have a Q&A session. And I'd suggest that if anyone would like to ask questions, please feel free and please use the Q&A function for that purpose. My apologies in advance if I don't have time to pick up all of the questions. As Professor Buckley isn't able to join this evening, we might have a bit more time for Q&A. We'll see how we go. But at the end, I'll invite my colleague, Professor Rosemary Langford, who's the Director of the Melbourne Centre for Commercial Law, to close the webinar, and we'll look at finishing on or at least before 7:15. So that's what we have in store for you this evening. Thank you very much for joining. Let me now turn to Douglas with the first question to kick off the discussion. Douglas, I have a broad question about regulation and the design of regulation. How do you think our experience with FinTech has changed the way in which we think about regulation and regulatory design? I know, for example, that you, Ross and Dirk, devote a chapter in your new book to what you term smart regulation. What's that about, smart regulation, and what impact does it have in terms of the style of regulation that we might adopt to deal with these technological challenges, whether it be a move towards a more principles-based approach to regulation or adopting a more risk-based approach, depending on the technology that's involved? So perhaps I could ask the first question of you to kick off today's webinar.
Thanks for that, Andrew, and thanks, Andrew, Rosemary, and the team for organizing everything. And likewise, I'd like to extend Ross's apologies for not being able to join today. You know, in looking at this question around regulatory design and this idea of smart regulation, you know, I think what Ross and Dirk and I have been very fortunate over the past 15 years or so to be deeply embedded in this entire evolution of what one can think of as the FinTech era, which in many ways starts with this period after the 2008 financial crisis. We see very rapid development of a series of new technologies, their applications to financial services, and over the past 15 years, continuing discussions about how can we best go about balancing the opportunities and the risks that come out of the opportunities of applying new technologies to financial services. And you know, I think when we think about this idea, it's important to realize first that from the standpoint of finance, technology, money, always co-developmental. But if we think about finance today, we often think of finance as one of the world's most digitized industries, but finance isn't a digitally native industry. It is an analog industry that over an extended period of time has transformed digitally, but over the past 15, 20 years at an increasingly rapid rate. And from a legal and regulatory perspective, where many of our traditional approaches were designed in the context of an analog understanding of finance, this speed of digitization has been a real challenge. And so, as Andrew suggests, we spent a lot of time trying to think about the best regulatory approaches to this process. We can also think about finance as one of the world's most globalized and one of the world's most regulated industries. And this particular combination means that often we're dealing with new technologies in finance, but in a different way than we might be dealing with them in the tech space generally. In other words, if you are bringing a new technology into finance, you are bringing that new technology into a mature and regulated industry, which is often operating on a cross-border basis. And so we really took the opportunity with this book to try to draw on past 15 years of discussions, experiences with the range of new technologies which we've seen emerge, and try to draw both some lessons about what we've seen in terms of approaches, but also in thinking really forward to how do we go about dealing more generally with new types of technologies. And I think in many ways, the starting point is this idea that if we think about the digital transformation that has happened all across the world over the past 15 years, we can think of it from different levels. One aspect has been in the context of infrastructure systems like payment and settlement systems, digital identity systems. One can think of it from a second level from the standpoint of regulation and regulatory approaches. And one can think of it also from the context of the wider ecosystem. And I think in the context of Andrew's question, it really comes to this idea of the regulatory approaches, that sort of second level of this broad structured idea. And I think we've looked at the evolution of a range of new technologies trying to deal with innovation, and we've seen a variety of different strategies adopted by governments. And I think the emerging best practice is a combination of a number of different elements. Often the first level, and in some ways one of the most important, is for the regulator, the policymakers, to gain an understanding of the emerging new technologies, of the business models, of the institutions that are applying those. And this is a challenge because if we think 15 years ago, finance was a much slower industry. But at the same time, while a challenge, it's also a learning opportunity to see how things can be done differently and done better. So the starting point is really for regulators and supervisors to spend the time to engage, to understand what is going on with technologies and markets around them. And we find that an important part of this is an innovation hub, some sort of enabling support mechanism to help market participants understand why we regulate things. And I think it's very important because often people come into markets and they think that regulation is all about control. And often regulation is really about trying to address problems that evolve in the context of markets. It's about efficiencies, it's about market failures, it's about dealing with frauds. And so the idea of this base of an innovation hub helps people to understand the regulatory system, but it also helps regulators to gain an understanding of the new technologies. This can be supported by some sort of sandbox or test and learn or piloting program, which enables the regulator to work closely with firms offering new technologies to gain a good understanding of the risks and the opportunities. And what we're seeing is that increasingly regulators are then designing regulatory frameworks that are not necessarily focusing on specific technologies, but very much focusing on functional issues. Maybe we're looking at payments. Maybe we're looking at fundraising mechanisms. Maybe we're looking at digital assets. Each of these, we're seeing the evolution quite rapidly of comprehensive designs for regulatory systems around the world. And often core to these is that idea that Andrew was highlighting about a different approach. And we frame this as a proportional, risk-based, graduated approach. And what we mean by that is you want to encourage new entrants and new firms, and you want to make it relatively easy to enter the financial markets. But at the same time, you want in place the same sorts of rules and protections which we have for functionally similar products and services. We can often think of this as a sort of activities-based licensing approach. But as firms, as their offerings grow more and more significant, one needs to give additional regulatory attention, moving from licensing and registration to supervisory approaches to entity-based regulation as things become more and more significant. And this is one of the challenges that we're seeing in the context of financial services, is that things move very, very quickly, that things can move from what we categorize as too small to care to large enough not to ignore to, in some cases, too big to fail. And how do we balance the opportunities that come from the network effects of data with the economies of scope and scale of regulation? And really, the fourth piece of that is one that Andrew mentioned, and that is the regulators themselves to increasingly use technologies in pursuing their regulatory objectives and regulatory functions. In the same way that we're seeing a lot of strategy lessons for countries that are looking to transform their financial systems, that are looking to support appropriately balanced financial innovation, we also see very large numbers of central banks and regulators all around the world which are engaged in their own digital transformation processes, usually a process of digitizing their own operations, digitizing all of the various sorts of data that they collect, digitizing their approaches to analytics, adding in big data approaches, in some cases, artificial intelligence approaches. And generally what we're seeing is that as regulators digitize their own internal processes and systems, they then begin to engage more with digitizing the way that industry submits information in the context of reporting requirements to regulators. And we see a real trend towards digital regulatory reporting, a drive by regulators and supervisors to then monitor the internal systems of financial institutions to make sure that they are capable of delivering the necessary regulatory and compliance information from the standpoint of enabling analytics by regulators and supervisors. And Andrew, I think from my standpoint, this idea of smart regulation is this combination. It's the idea of regulators focusing on learning about new technologies. It's from the standpoint of designing appropriate systems to support and enable innovation, but with the understanding of regulatory objectives. It's about the design of appropriate legal and regulatory frameworks across functional areas. It's about balanced risk-based approaches to regulation, and it's about regulators and supervisors using technology in the context of their own processes.
Thanks very much, Douglas. You've touched on a number of really interesting issues there. You mentioned the digital transformation in financial services and the impact that that's had. You mentioned also the extent to which regulators themselves are having to engage in digital transformation. And that's all part and parcel of the trend towards regulatory technology, or RegTech. So it's probably a good point on which to draw Kate into the discussion. Kate, you and your colleagues at ASIC, including ASIC Chair Joe Longo, have spoken extensively about the regulatory challenges presented by FinTech and the need for ASIC to undergo a digital transformation particularly in order to utilise artificial intelligence better and become a smarter and more efficient regulator. And I think that resonates with what Douglas was saying about the move towards smart regulation. It's not just to move towards smart regulation, but a move towards smarter regulators. What do you see as the primary areas of transformation, at least in terms of ASIC's remit? And what do you think are the primary challenges that lie ahead? For example, is the regulation of data and financial information a key issue in this regard? And if so, why?
Thank you, Andrew. Thank you, Douglas. And hello, everyone. Lovely to be part of this evening's event. So yes, I'm from ASIC, the Australian Securities and Investments Commission. So we're the securities regulator. We've got fellow brother and sister regulators in APRA, in the RBA, the ACCC and Treasury. And together we really have been leaning into the real challenges and fantastic opportunities that this webinar is exploring. I'm going to structure my comments around the kind of framework that Andrew set out, because as I was listening to, that Douglas set out, because as I was listening to him, I was thinking about how all of those different steps are in play for a regulator like ASIC, with the addition of us having to kind of stare into risks as they are now with the regulatory frameworks that we've got here and now. So that will be just an additional element. So stepping right back to Douglas's first description of the importance of regulators really listening and getting to understand what the new technology is, but also what new firms are emerging and how new technology is being used in existing firms. That's something that ASIC's been really interested in and committed to over the last period of time. And our current really intense focus is on the use of AI in financial services. So when I say financial services, banking, superannuation, insurance, credit, financial advice, we're in that very much open mind exploratory stage at the moment with a series of inquiries that are out with a whole series of firms to understand, well, what does AI look like in financial services? What are firms using it for? What successes are they enjoying? Where are they finding difficulties? So it's occurred in earlier steps in relation to other technologies, but I was just really struck by that description of the importance of kind of curiosity and listening and understanding how things are used and how things are emerging. The second area to mention is that we do have an innovation hub as a regulator, and indeed there's an enhanced regulatory sandbox that ASIC administers that Treasury set up. So those ideas of understanding for new firms, for the firms coming in or people who are new to being regulated, which can be a bit shocking, I think, particularly in financial services. I think I agree there's a high level of regulation. Just understanding what those frameworks are, whether they're financial services license or credit licenses or some of the other frameworks that apply in Australia. We have an ASIC Innovation Hub, which allows for people to come in and explore whether or not they can both learn about the frameworks, but also have limited in the sandbox relief from some of the obligations for a period of time while their products or services are under development. So the ASIC, the Enhanced Regulatory Sandbox, provides that kind of more specific relief, and then the Innovation Hub has a wider range of services to really support people learning and understanding and then shaping some of the products and services that are emerging as well. We've got as well what we call a DFAP, which Ross chairs, Ross Buckley. So that's a digital finance advisory panel, where we do have an opportunity to hear directly and to share information directly with members of the Australian FinTech community, RegTech community, SupTech, all of those phrases that were being used. We really like that. We just had one last week. Really interesting to hear about what's happening in the corporate sense in terms of, numbers of startups and when people go revenue positive and things, but also the technology itself, the sort of products and services that are being developed. So lots of positive facilitative aspects of the work that ASIC does. But by the same token, we also have to kind of grapple with applying existing rules to new harms. So I don't want to overstate the harms, because I really do recognise, and we are a big part of facilitating the opportunities and ensuring that we get great new entrants, great new financial products and services. But we do, as the regulator, have to lean into the fact that there can be some pretty serious impacts on consumers. and on markets. So we can see market stability being, I think that was alluded to, we can have sort of stability issues. When you've got automated decisions in markets, you can have really very high levels of volatility, and you can have extreme market events that can occur. There can be market abuse, whether it be machine learned or algorithms or other ways that things can be really amplified. Misinformation is a risk that we can see. Bias and unfairness, like if there's systematic decisions that are being built in through AI or otherwise, you can exacerbate bias and unfairness. Scams and fraud are often enabled or enhanced through use of generative AI or indeed other tech, FinTech. Cybersecurity risks are self-evident when we have had those sorts of problems. And then data privacy, transparency. So there are big problems that can occur. And what we've been doing at ASIC is trying to use our existing tools to the extent we can, and also being really constructive partners in the design of new regulatory frameworks as there's new products and services and new threats and harms. So a couple of the examples on the existing use of our existing laws. A lot of existing laws are principles based. So, if you think about directors' duties, the Section 180s, it's based on general principles that can be applied even to AI or to financial innovations. And we have been using existing laws. So a couple of examples in relation to AI. There was an entity that held an Australian financial services license called RI Advice, and the federal court found that it breached those license obligations, and particularly to act fairly and efficiently, because it failed to have adequate risk management systems to manage its cybersecurity risks. So using the AFSL requirement to act efficiently and fairly to address kind of an emerging cyber risk. ASIC's also commenced action against IAG, So this case is alleging they used an algorithm to identify longer term or loyal customers and then allocating them higher premiums before then promise discounts that applied across the board. So that one's still in play. Don't know where that one's going to land. So we're using existing laws. We've released guidance. And like I said, the other thing we're doing is really participating with our fellow regulators in relation to new payments frameworks, consumer data right, digital identity, the Privacy Act, digital assets. Like there's a whole set of reforms that are really straight out of the kind of issues that FinTech are emerging. And we want to make sure that they are well designed, some of those principles about smart regulation that Douglas mentioned. So I just thought I might finish on ASIC's own use, because I think that was a really interesting way that Douglas as well finished about, well, what about regulators themselves? What are we doing to make sure we have a digital transformation? And I think, Andrew, you kind of referred to our chair, Joe Longer. This is one of his real passions about ASIC being digitally enabled and a more ambitious and confident regulator as a result, so that we have these fantastic tools available to us. So we are looking at how we can use great tools internally with a view to cutting down on standardised high-volume manual processes for us efficiently capturing and storing information and harnessing data, and so we can make faster, smarter regulatory decisions. So there's some general kind of goals, and that we've got some particular tools. So we've got a project Artemis, which uses advanced algorithms, and that's in our market space. So it maps out connections between trading movements and individuals, and so we can see suspicious trading. But we've got other tactical solutions as well. Most of our really sort of most advanced things are in our market space, but we also have thinking about in other financial services and some of our other areas as well. So lots of projects underway so that we can both make our internal skills and capabilities stronger, but also for people interacting with us in terms of digital front door, ease of use, really improve that as well. So I might finish there and hand back to you, Andrew. Thank you.
Thanks very much, Kate. You touched on at least 3 points that I thought were very interesting, one of which is the measures that ASIC has taken to support innovation and to keep up with developments from a regulatory perspective. You mentioned sandboxes, and also, of course, the innovation hub that ASIC manages. As we'd all be aware, I think this a trend that's occurred worldwide. But Australia's sandbox is in some respects quite unique. The enhanced sandbox that exists in Australia, it does work differently from the way in which sandboxes work elsewhere. And perhaps one question that we might come to later on is just how successful and effective, Kate, you think the sandbox has been in the innovation hub. It's very difficult for academics like myself to get information about sandboxes because a lot of it is commercial in confidence, but it would be good to get a general idea about how effective you think our sandbox has been, whether just by reference to developments in Australia or by reference to models in other jurisdictions. So that was one point that I found very interesting. Another point you mentioned, of course, was the use of technology for regulatory purposes and the extent to which ASIC has been innovative in that regard. It's one of the words that often comes up in this context is interoperability, the extent to which, for reporting purposes, for example, as Douglas mentioned, firms that have to have reporting obligations, can provide information to the regulator in a way that enables the regulator to use technology, artificial intelligence, to monitor, to supervise, and to process the data in an effective way. And the third area that you touched on that I thought was very interesting was the question around enforcement and the extent to which ASIC is pursuing enforcement action. You mentioned the RI advice case, and you mentioned the other one. And I couldn't help but think about the ongoing challenges that arise in the context of robo-advice, particularly given the fact that our regulatory framework really doesn't seem to be set up to accommodate automated advice or robo-advice, certainly in relation to personal advice as distinct from general advice. So that's another area that I think it might be interesting to pursue in the Q&A if others don't have better questions. And I've already caught sight of a couple of really good questions that have come through, so please don't hold back. If anyone has questions they'd like to ask of Kate or Douglas, you'd be very welcome. So Douglas, if I could bring you back up onto the screen. You mentioned before the extent to which regulation needs now to focus on new types of technology. And I think one thing that might be said, and one lesson that we've learned from the experience in FinTech, is that it's certainly not the case that one size fits all, because of course you've got different institutions, different entities doing different things. You mentioned the benefits of functional regulation in that regard, but how challenging do you think is it to deal with specific technologies in this context? You mentioned artificial intelligence, I think also distributed ledger technology, blockchain, and also, of course, issues to do with the use of big data. And so any thoughts around the challenges presented by specific technologies? Is it possible, do you think, to adopt a one-size-fits-all approach? If so, what might the template look like? If not, then how do you think we should go forward? What are your thoughts about that?
Thanks for that, Andrew. And yeah, I agree. Some really interesting remarks from Kate, and really interesting to hear what they're doing. I think from the standpoint of, is there a general approach? I think this idea that we are suggesting around the structure of smart regulation is a starting point. I think the hard thing is that one isn't necessarily regulating a specific technology, but rather you are looking at activities, participations, the sorts of things that people are doing. And I think one thing that may be worth thinking about is, as we look forward, what are some of the big issues and challenges that we're seeing right now, and in particular, the ones that we think are really for the rest of the decade going to be driving issues and driving challenges. And we actually have identified 5 that we really focus on. And the first is one that's been flagged, and this is the digital assets industry. And this one, I think, is particularly interesting because after 15 years, this year and next year, in a significant number of jurisdictions, digital assets are becoming a regulated industry. And this, I think, is a very important step from the standpoint of the evolution of digital assets. We've been talking for 15 years about what sorts of approaches, but in a group of jurisdictions, one can think of Hong Kong, Singapore, Japan, the EU, UK, Australia, Switzerland, UAE, basically approaches that are around licensing, around supervision of intermediaries, around enforcement of behavioral issues, specific frameworks in many cases for regulated stablecoins, and frameworks for market integrity and AML. And basically, in this group of jurisdictions, from sometime in the next year, digital assets are a regulated industry. And I think that that is going to be a very different environment. It's going to be very interesting to see the competition that emerges between the participants in the industry going forward. So I want to flag that one first as what I think is one of the most interesting areas going forward, digital assets from this year as a regulated industry. The second, I think, is just as transformational. We've been having discussions for an extended period of time about many of the issues in cross-border payments. And if we think about payment systems, we've had really a 40-year technological transformation. We can think about the development of electronic payment systems. We can think about real-time gross settlement systems, which are now in place in over 135 different countries. We can think about the advent of mobile money and mobile-based payment systems, things like M-Pesa, Alipay, WeChat Pay. We can think about the development of cryptocurrencies, of stable coins, of fast payment systems, and most recently, central bank digital currencies. And all of these pieces are coming together, both in the context of a regulated digital assets industry, but also in the context of a number of major projects in the context of rebuilding cross-border payments. And the two that we think are the most interesting, one is about linking domestic fast payment systems. And instant or fast payment systems have evolved at really incredible pace. 10 years ago, very few countries had them. Today, somewhere between 70 and 100 countries have retail instant or retail fast payment systems. And now we're seeing a number of initiatives about linking those domestic systems to enable cross-border retail payments just on the basis of mobile phone numbers. And I think that this is probably going to be transformational from the standpoint of cross-border retail payments. Similarly, we're seeing some very interesting projects linking wholesale central bank digital currencies and RTGS systems in the context of enabling easier wholesale foreign exchange transactions, which should address the second aspect of cross-border payments. And I think as these systems come in, this is going to have a major impact from the standpoint of what has been one of our long-term grand challenges in finance, and that is inefficiencies and problems in cross-border payments. The third we've already talked about, and this is around RegTech and SupTech, particularly around analytics by supervisors, the development of regulatory reporting, the use of digital ID systems for individuals, but also for entities, and the development of a range of reporting infrastructures, WINGS in Hong Kong, for instance, or what is going to be the European single access point, a single reporting framework for digital company information in the context of the EU. These are major transformational regulatory trends that are going to play out over the rest of the decade. The fourth is very significant, I think, as well. And that is in the same way that digital assets are becoming a regulated industry in a important group of jurisdictions, sustainability reporting requirements are likewise becoming mandatory in an important group of jurisdictions. And once reporting requirements around sustainability become mandatory, it changes the entire way that the industry approaches these. It also creates entirely new data sets, which can then go into various forms of decision making around investment, development, etc. And finally, that takes us into what we identify as the fifth area, which is really around data aggregation. In other words, how do we maximize the benefits of data while also trying to minimize the risks of concentration and dominance, which can easily emerge as a result of network effects in technologies and economies of scope and scale in financial services. And this is at an early stage. We're seeing a range of countries that are looking at new data protection frameworks, new data strategies, as well as new systems and infrastructure to enable use of data, things like open banking, open finance, open data. And I think what I want to really take away from these 5 examples is not necessarily that we're looking at a specific technology, but we are looking at the way that technology impacts markets and regulation. And from the standpoint of regulatory approaches, we have to think about all of these pieces together. It's going to be a lot to take in, but I think if we think across these 5 trends from the standpoint of technological developments in markets and their regulation, I think we're looking at some really exciting changes over the rest of the decade.
Thanks, Douglas. Kate, could I bring you back onto the screen, please? I think it's probably a good time now to initiate the Q&A session, and keep those questions coming, everyone. One question for you, Kate, that I thought would be interesting to raise, and that is Douglas's point about the extent to which payment systems have really been the forerunners in terms of the regulation of digital assets, particularly in the form of digital currencies. And we do have, of course, a definition of digital currency in the anti-money legislation, anti-money laundering legislation, but that's about as far as it's gone in Australia. It's different in other jurisdictions, but we've tended to rely perhaps more on regulatory guidance than on legislation to deal with the challenges brought about by technology and financial technology. But during the course of the inquiry by the Australian Law Reform Commission, we looked at this question of the impact of new technologies, and we thought, well, it probably doesn't always make sense to regulate by reference to technology because it'll become out of date very quickly. And as Douglas mentioned before, it's very difficult, if not possible, to regulate a specific technology. But nonetheless, it does make me wonder whether we do need to have some agreed understanding of digital assets in order to hang certain obligations off them, in order to enable the regulator effectively to pursue enforcement and do its job. And so I'm interested to know your thoughts about where you think things are going in terms of the breakdown between regulatory guidance and legislation. In the EU, for example, they've now enacted the MiCA reforms. And so they've been quite granular in terms of the extent to which they've defined different types of crypto asset or digital asset. Where are we in Australia on that, and what's your perspective?
Yeah, no, thank you. And I'll draw, just for people's benefit, before I was at ASIC, I was at Treasury for 6 years, so reasonably recently, and so with the benefit of having spent some time there and now wearing my ASIC hat, being part of the discussions that have been ongoing in relation to the digital assets, so the crypto work that's been released, but also the payments work and others. I think it really does raise some of those questions that you are alluding to around well, how do you step back from the particular technology that's being used and think about instead, well, what does it either mean for activities, products and services that are being offered? In the payment space, there's been a lot of discussion about, well, what sort of payment service the provision of payment services, how might that look, and how do we categorize it and appropriately kind of put different regulatory weight depending on the risks or those activities are there. So there's definitely a question about around that, but there's also, and what are the best regulatory tools? Do we use legislation? Do we use regulation or some that's, legislative instruments? Do we use codes? Do we use guidance to try and build a degree of flexibility in that can make our frameworks that are new a little bit longer lasting, and try and be flexible enough to both recognise that the technology is moving quickly, but also the risks and opportunities that might come are better served if we've got a degree of flexibility. The other thing I'd reflect on when we're designing regulatory frameworks, and this was so in relation to the Consumer Data Right, the open banking, which was something that I worked more closely on in Treasury, is just the importance of, as the regulator or as the Treasury official or whoever, as a team having access to the technological know-how and the support that is required, especially when it is a network model which requires people to comply with the law in the same way, otherwise the system doesn't work. So in relation to the Consumer Data Right, it was really important that people comply with the data standards, or do comply with the data standards consistently, because otherwise the information doesn't flow if they've set things up differently. And so making sure that we've got good systems with capability for people to be administering them in a way that's really effective in partnership with the participants is another important part. Responding to your question about designing regulation well and then executing it well, I think it takes careful thought and design and collaboration to do that.
Thanks, Kate. We've had a few questions from our colleague, Pamela Hanrahan, Professor Hanrahan.
Hello.
And thanks, Pamela, for the questions. I'm just trying to work out which one would be the best one to pick up at this point. Pamela had one question, Kate, about the survey on the use of AI by regulators and the progress of the government task force in that regard. Anything, any developments to report in that regard?
I think what Pamela's referring to is the work that Minister Husic has been leading, and I think Department of Industry, Science and Resources it was an extraordinarily rich consultation process, so much interest from so many different perspectives, and I think I would defer to colleagues from that department to give a really more complete update. But for me, what I've seen is that sense of trying to think about, well, at the highest level, where are the highest risks? Okay, do we want guardrails? That idea of not being diving too deep too quickly. Back to sort of Douglas's suggestions right at the beginning about the value of understanding and both the service, the products, the technology, but the impact. And the point I was making, well, what's the current system? How does the current regulatory framework apply? When we were talking earlier about, when Douglas was talking earlier about digital assets and the new kind of licensing intermediaries conduct issues, I was thinking about how we have really found it difficult to apply our existing definitions of financial services to crypto assets. So we've had two recent cases for ASIC, one of which a crypto asset was found to be a managed investment scheme, and the person offering it was doing so in an unlicensed way. So there was a finding in favour of ASIC. Just last week, there was one where it was found to be not a debenture. They're such old-fashioned, they're such traditional concepts. They're absolutely not designed for trying to be fitted around crypto. And yet, as the regulator, when we see existing harm or what we think is harm, we've got to use the tools that we've got to hand. So that's why, as well as doing so, we're really keen to have good design and be part of the systems, the new emerging frameworks that are happening.
Yes, it certainly does throw up challenges for this principle of technology neutrality, because traditionally, if we wanted to implement that strictly, we'd say, well, we should refer to technology or regulate by reference to technology at all. And that's partly because technology is changing constantly. But it seems in the new world of digital assets, it's inescapable that we need to identify it and work out what it is we're dealing with. Douglas, another question from Pamela, which I thought I'd throw your way, and that is whether Australia needs a digital currency, at least according to Yanis Varoufakis recently suggested that we did. And so thoughts about that. I know for some years the RBA has been looking into it, but I guess consistent with the way in which we tend to look at things in Australia, we think, well, let's wait and see how others go and learn from their efforts. How inevitable do you think it is that countries around the world, not just Australia, but countries generally, will adopt a digital currency? And what's the best way to proceed in that regard?
I think this is actually, it's a really interesting question because, as I mentioned, if you think about the sorts of digital transformations that we've had in payments, we've seen really a spectacular period of change over the past 15 or 20 years. And particularly since Facebook's proposal in 2019 to launch its own cryptocurrency, which was initially called Libra, we've seen an absolute explosion in the numbers of central banks around the world that are looking at central bank digital currency projects. The Bank for International Settlements and the Atlantic Council, amongst a range of others, run more or less up-to-date trackers. And I think we're looking at somewhere between 120 and 140 central banks around the world that have projects at varying levels. But it's interesting because I think we're seeing a wide range of different motivations and opportunities. The simple exploration process, though, I think is useful. I think for any country to explore the technologies, to think about the potential implications, to understand what others are doing, these are important. But I think if we look at what we're seeing, we can kind of divide it in some ways between the retail position and the wholesale position. And I think quite a lot of countries are finding, particularly if you already have some sort of fast payment or instant payment system, that a retail CBDC may be a useful backup in case that system goes down. It may be a useful alternative for those who, for whatever reason, are unable to access the fast payment system. But it's increasingly difficult in many developed markets to say that a retail CBDC is necessarily going to transform everything. It's coming into quite a crowded landscape. With that said, it's interesting to see that we are getting FPS, we're getting crypto, we're getting regulated stablecoins, we're getting a variety of CBDCs. So that's an interesting environment. I think in some ways, the real interest, particularly in developed markets, is on the wholesale side. In other words, the ability particularly to think about foreign exchange and large value cross-border payments, as well as to think about from the standpoint of embedding payments into wholesale financial transactions, bond markets, debt capital markets, et cetera. And so from my standpoint, I think it really is worthwhile for just about any country to spend some time investigating this, but really whether you actually need to go down the route of a retail central bank digital currency, a lot depends on your own landscape. For a developed market, though, I suspect that wholesale CBDCs, particularly when one thinks about distributed ledger technologies and digital assets, is going to be a very useful tool going forward.
One expects perhaps, Douglas, that the question won't be if, but more when, and if not, why not? Australia and other countries might adopt a digital currency. Kate, I'm not sure whether you have anything to say in that regard or whether you'd prefer to leave that to your colleagues at the RBA.
Well, it's something that, we were a small part in the work that has been done. And it goes back to the question, which I might circle back to, you asked about our innovation hub, and that obviously we didn't throw the RBA in the innovation hub, but what I mean is that idea of facilitation and the degree to which, as the regulator that under the Corps Act has quite significant capacity to modify and exempt people from the law, and it's on the basis of that we have this idea that we can, for a kind of limited period of time, when there's a small number of customers, we can kind of switch off some of the obligations so people can trial play in the sandbox. We did, as part of the work that the RBA led in relation to digital currency, we played a small part in that regard. But I also wanted to come back to the question you posed to me earlier about, well, how many people have used the sandbox? So I've got a stat since December 2020. So we've had 70 entities come and test whether they can, but 15 actually got to the point of jumping in, going through all of the steps required to actually get to a point of testing a product or service in the sandbox. And for people's benefit, what that generally involves is an up to a 2-year period of time in which you don't need to have the full license that's required associated for the particular financial product or service. So that's a little bit of information on that, and happy to take offline anyone's queries for more information about our innovation hub.
Yes, well,
they're an important part of us being part of this ecosystem.
Yes, Nicole had a question about how successful the regulatory sandboxes and innovation hubs had been. If I'm not incorrect, I guess they received a bit of a boost as a result of COVID, as technological development did generally. And 70 applications is probably not a bad outcome in terms of the initiative in the first place.
Yeah, look, I mean, we can't overstate it. It's hard to start a new business. It's hard to develop new technology, even with fantastic new technology tools or new data aggregations or whatever. There's still a lot. I've seen from working on the CDR just how much work goes into development of products and services and the sort of support that people need, not just on the regulatory side, but in all sorts of ways. So can't overstate it, but doing a small part to contribute.
Very good. And in relation to data aggregation and all of that related stuff, I can't help but ask a question in relation to our model. And it picks up a question that Dr Ranjan has asked about data aggregation and the extent to which in other jurisdictions, FinTech regulation and data protection have been undertaken by different sectoral regulators. In Australia, of course, we don't have the same challenge, given that we have the Twin Peaks model. But nonetheless, we do see RBA as the payments regulator. We do see ASIC as the conduct regulator. And indeed, we've got APRA as the prudential regulator. And somehow we need to coordinate and make all of the initiatives on the part of each regulator effective. Is that a challenge, do you think?
It is, but one that we are very live to and have frameworks to assist in addressing. So the first one to mention is the Council of Financial Regulators. So that's RBA chaired, but Treasury, APRA, ASIC, and so the four, and ACCC come to some of the meetings as well. And so a really important forum for talking about issues that cut across in the financial regulatory space, including the ones that we've been talking about and many others as well. I would also call out that we do have intersections with our Attorney General's portfolio colleagues. So if you think about the Privacy Act and some of the work that's really important, and our Office of National Data Commissioner and the Information Commissioner and the Privacy Commissioner. So there's a lot of other parts of the system that do need to come together. Sometimes I think probably from the outside it looks like, oh my goodness, there's so many of you, but I can assure people there's a whole range of different forums and interdepartmental committees and interagency working groups. If I think about scams, we've set up this National Scam Centre that ACCC and ASIC are working really closely, but we've got industry advisors on it and Treasury involved. So there is a recognition. You can't set up a new regulator every time there's a new technology or a new system. Like, we have to adapt what we've got, and we work closely with RBA on payments. We work closely with ACCC on scams. Like, it's a partnership model. With APRA, we do all sorts of things in financial services.
Thanks, Kate. Douglas, a question from James, and this relates to what you were saying before about the use of technology to facilitate cross-border payments. And James's question is whether the increase in the ease and speed of cross-border payment systems increase the likelihood of transnational fraud. And I expect the answer to that would be yes, particularly if you're dealing with real-time settlements. And it also resonates, I think, with what Kate said about scams and the extent to which it's so easy today for people to send funds from one point to another. Even more so if you've got technology to help you do this across borders. What are your thoughts in terms of dealing with fraud in a cross-border context?
Yeah, this is, it's a general issue because the first level is, I think, whenever you have any new sort of technology in finance, you likewise immediately have fraud and crime. But you also, and it's interesting, we look at this sort of digitization, one thing that we've seen is that digital crime has been one of our most rapidly increasing aspects. And so this is ubiquitous across everything. And none of the new technologies, whether it's crypto or anything else, has actually changed this. I think as long as you involve human beings, you're going to get fraud, crime, misbehavior. And that means that at the very least, finance requires this sort of intervention. Now, from the standpoint of cross-border, yeah, it gets more complicated. And this is one of the issues that has been a real challenge, for instance, in digital assets, particularly, maybe we have a framework at some level in the context of the IOSCO multilateral memorandum of understanding, and that works well for the jurisdictions that are willing to identify digital assets in the context of their scope of authority as securities or financial regulators. And that's an increasingly large number, which I think is significant. Now, if we deal with payments, it's absolutely the case, and it doesn't matter whether it's domestic or wholesale, that as we add in more and more types of faster and electronic payments, we get more and more forms of fraud and crime. And I think that this is one thing that, as we've looked at many forms of settlement, we've often concluded that absolutely instantaneous, permanent, and non-retractable is often not necessarily a good thing. We often might want a little bit of a delay. We might want some ability to retract, change, track down. And I think this is an important lesson as we think across financial markets generally, that faster is not always the solution. And at the end of the day, we have to realize that no matter what the new technology is, there is going to be someone who is already trying to figure out how to use it to relieve others of their money.
Very interesting. One question I think I could throw at both of you, and it comes from Rachel, and that is, with all of the technological developments, it's becoming increasingly important, of course, to have people who have an understanding of technology, who have the technological expertise, whether it be in the regulator or whether it be in industry. Are you seeing an increase in both the number of people who have expertise in this area and also the quality of the expertise that they have? Are we as humans keeping up with the technology ourselves? And if not, how should we go about remedying that? Perhaps I could ask you first, Douglas.
I'll throw it out and then I'll see what Pamela says in the context of what they're seeing on the ground. From the education standpoint, this is a major challenge. How do we think about sort of increasing the understanding and abilities, both from the standpoint of students, but also from the standpoint of executive education, professional development, et cetera. And I think the starting point is to realize that not everybody has to be an expert in the specifics of the technology, but almost everybody can understand how systems work or how they can use them in their day-to-day activities. And to a certain extent, I think that the mobile phone has introduced that to most people, the fact that the vast majority of people are now dealing with what we would have thought of 30 years ago as a supercomputer. That's one. But second, ChatGPT. And the easy access to generative AI and the fact that it's been the most rapid take-up of any technology in history. We're finding it easier and easier for people to interact with these new technologies. But that means it becomes ever more important from the standpoint both of young people as well as professionals to be able to get up to speed and understand what is going on, to figure out how it's likely to impact not only their professional development, but also just their day-to-day lives.
Kate, how's ASIC faring in that regard? Are you all becoming much more tech savvy?
Yeah, we've certainly got a lot more people who are expert. And for me, then it becomes both about having those people and welcoming them into what is traditionally a house full of, a building full of lawyers, few economists and things. So we've got a very big new part of the organisation in our technology and transformation teams, but also then at a higher level, the organisational culture that welcomes such diverse perspectives. When you're tackling common problems, whether it be misconduct or fraud, or on the other end, facilitation and innovation, you need to have a culture which listens to each other. So the lawyers listen to the tech experts and vice versa, and all of us have kind of clear common goals and ways of communicating that are effective. So you get the benefit of those kind of that technology expertise, but you also have people understanding regulatory frameworks and discussions that can bring them together. The other point I'd make that I've seen in the market is setting ASIC aside, but just more when I'm thinking about businesses, companies and small businesses right through to really large listeds, is a real appetite from directors and executives for learning more about technology and particularly cyber risk. You can understand why they're really worried. But so just, when you hear about what the most popular courses are, AICD, Governance Institute, those organisations, no doubt your teams are offering, almost an insatiable appetite for people to understand more, even if they don't have a tech background, to understand the risks and their responsibilities. And then, at the SMEs, there's a cyber wardens program where the simple idea is that someone can get a little bit of information and be able to be available to be kind of the first point of contact if there is a cyber hit, is really valuable. Like even a small improvement in cyber hygiene or responses can make a big difference to a small business if it's under attack. So I think, there are ways of us all collectively getting better, and part of it is about us also being good at listening to other people's expertise.
Very good. Kate, Douglas, that's been a really interesting discussion. We could keep going all night, but unfortunately time doesn't permit us to do so. And no doubt each of you has better things to do with the rest of your day. But thanks very much. I'll now call on Rosemary to say a few words of thanks and to close the webinar. Rosemary.
Well, thank you so much, Kate and Douglas, and also Andrew, for those fascinating insights. There's certainly massive challenges caused by fast developing technology in the financial services area. And on a personal note, I'm very glad I didn't have to answer the questions that you answered. So thank you so much. Thank you to all of you for attending as well. We do have a number of other events coming up this year at Melbourne Centre for Commercial Law, including some on AI. Also, Douglas mentioned sustainability reporting. We've got a big event on that in August as well. So please do, if you haven't already done so, register to receive our newsletter or follow us on LinkedIn if you would like more details of those events. But again, thank you so much, Douglas and Kate and Andrew, for those fascinating insights. Really appreciate it. Thank you. Thanks, everyone.
Thanks, everyone.